gavel the thing. Okay, this case is coming to order. Gray v. Summers. At this point, I'd like to hear from the counselor representing the plaintiff first. Go ahead, counselor.
My name is Bridget Casey, and I'm here representing Ms. Gray on her behalf. Imagine yourself in Ms. Gray's shoes. You just got a new job with a new company. You don't know anyone, but you do know that you're under a trial period for 6 months, and you're going to be under strict scrutiny by everyone in the office, especially one man under the name of Mr. Summers. This is your dream job with killer benefits. You studied in this field and are more than qualified and capable to handle every task that they throw at you with ease. This could be the job that launches your career. You begin working and everything is great, and then the man who determines your future, your successes, or your failure, gives you a nickname.
Counselor, I'm going to stop you right there. I think one of the important parts of this case is about Mr. Summers, but I think it's not exactly clear what kind of power he has over her. So explain that to me. What is his position at the firm?
So Mr. Summers has been at the firm for 7 years now. So he is well established and very respected. He's given special privileges and duties at the company. His first privilege was membership on the board that decides the distribution of company profits and losses.
Yes.
And his second special privilege was being solely in charge of the Xavier Mentoring Effects for New Employees program, which Ms. Gray is a part of.
How does this rise to the level of him being classified as an employer, though?
Well, Summers directly supervised all the tasks of every new employee and for a trial period of 6 months, and his recommendations were usually taken almost at their word when keeping these new employees on after their trial period.
Taken at their word, counselor, to be fair, he's giving advice, but he doesn't necessarily have a final say on any hiring or firing authority. Is it bother you that this period was only 6 months?
I don't think that's bothersome, but I think his respect around the office is what is the main issue here, not necessarily whether he has strict authority to hire someone.
Okay, continue.
So he gives Miss Summers or Miss Gray a nickname. You've had nicknames before, but the nickname he gives you is that of a porn star. Is there any respect for someone in that line of work? Will you ever be taken seriously by anyone else around the office who's now heard the nickname being referred to you as that nickname several times now? What's to be done? You can tell him that it blatantly makes you uncomfortable, sure, but someone who has great friendship with everyone laughs at his jokes and joins in when he is calling other people by these nicknames?
Counselor, I think I see the point you're trying to make. But you were trying to classify this as a hostile work environment claim, is that correct?
Yes.
I think on two levels I have a little problem with that, both of which you brought up. I think the first is the fact that Ms. Gray did nothing to indicate in terms of speaking out or seeking help in HR or outside of the immediate situation to express that she was uncomfortable. How would you respond to that?
So I think the issue with that is it's clearly stated is that Miss Gray never smiled, laughed, or continued the conversation after she was referred to in this way by Summers. He is your boss. He is someone who is respected and looked to with authority. The law does usually not cover isolated offhand comments, but this is not an isolated incident. Summers is said to have referred to Gray as Jenna Jameson, the porn star, at least 5 times publicly before creating the demeaning name tag that he demanded that she wear, then threatening to fire her if she did not.
Would you say that this was sufficiently severe or pervasive?
It is for sure pervasive. And pervasive in the way that it has happened 5 times that she can recall.
And to be fair, through my reading of the facts, it seems as if these were celebrity nicknames, celebrity lookalikes.
Right.
So if you are taking that perspective, that Jenna Jameson was given for her celebrity status,
Right.
would that not take this outside of the realm of sexual harassment?
Well, I think that begs the question, were other people nicknamed after porn stars? Mr. Summers even claims that these lookalikes, he boasted that these lookalikes he had seen an overwhelming majority of movies/TV shows that the celebrity had been featured in. That has a lot to do with sex, considering she's a porn star.
Okay, continue, counselor.
The nature of these comments are based on sex. They're sexual innuendos, and no one in the office can look at Jenna. No one in the office can look at Miss Gray without mentally undressing her and thinking of the porn star that she's now associated with. By definition, this is a hostile work environment. The actions are unwelcome, they are pervasive, and it is all based on sex.
Thank you, counselor. At this time, I'd like to hear from the defense.
Sure. Hi, I'm Sarah. I'm here to represent Mr. Summers in this case. So I would like to open with, not only is this a case of, or this isn't a case of miscommunication, but it's a case of lack of communication, as Ms. Gray did not voice any of these problems in the work environment. So there are many factors to consider in the background of this case, but I would just like to convince you that there was no violation by Mr. Summers, and his actions towards Ms. Gray in her time of employment at Xavier were average and done in a lighthearted manner, and they were meant to include her in the office, not to exclude her.
Now, in my reading of the facts, counselor, it does seem that she was not going along with this. There was never a smile cracked. There was never a word spoken. If we're going to look at this under a reasonableness standard, would it not be reasonable for your client to assume that she was uncomfortable?
I don't think so, based on the fact that whenever she quit, Mr. Summers was incredibly surprised. He was not aware that she was uncomfortable at all. And whenever she quit, he was surprised with her statements. Not only her statement that she was quitting, but that she was even feeling that way in the first place.
Continue, counselor.
Okay. So these were all done in a lighthearted manner and meant to include her and not exclude her. There was no intent by Mr. Summers to make Miss Gray uncomfortable in this break room humor, if you will. It was not intended. There was no discrimination intended. So under the Title VII, protected classes are race, color, religion, sex, and national origin. Physical appearance is not a protected class. And Mr. Summers, when giving her the nickname Jenna, was doing it in a celebrity look-alike manner, which is physical appearance. It's not a protected class under Title VII.
Now, I think, and that point is well taken, counselor, but in looking at the actual facts here, I find it difficult, and to Miss Gray's credit here, to point this out, to separate the fact that we are dealing with a porn star here. How is that not because of sex in and of itself? I mean, yes, there's this celebrity look-alike treatment he's giving everyone, but as the other counselor points out, that wasn't specific to porn stars. This is something that's different. So how would you respond to that in it not being because of sex, because of that fact alone on his face?
Sure. I would say that this isn't a unique behavior of Mr. Summers. Almost everybody in the office is known to have been given a nickname by him. It just so happens in this case that Jenna Jameson gained her fame through pornography. So this wasn't unique behavior. Everybody in the office, not everybody, but most people in the office were given nicknames, and it was a way for him to include people on a more lighthearted atmosphere.
Continue.
Okay, so his sense of humor was known around the office, and it wasn't ever intended to offend people. People were often laughing after his remarks or enjoying their time on their breaks. And overall, there just is not enough evidence to support a case of hostile work environment. Whether the comments were unwelcome, we can't really say because she never voiced that opinion at work. And additionally, when Ms. Gray quit, there was no tangible employment action on Mr. Summers' part because she was the one that quit. And because she didn't say anything at work, there was no reasonable effort made to prevent or correct on his part because he didn't know.
Well, he knew after she quit, did he not? I don't see any indication in the facts that he made any efforts to prevent or correct the problem afterwards.
If he would have been aware of it, he probably would have, but he was not made aware. Additionally, she filed no forms with HR and told no one else of this incident, making it very difficult to legitimize because nobody was made aware of this situation. So, Ms. Gray's statements, the fact that she quit, and then filed this suit against Mr. Summers were all a complete surprise to him because he was unaware of that his intention was taken as such. And his intention was really just to acclimate her into the work environment through welcoming her into the group with a nickname like other people.
And your point is well taken, Counselor. I find some problem with the language here. Now, you're expressing that there's no tangible employment action, but I'm reading this language. Give in and put this on. I would hate to see you get fired for not going along with this. I mean, if you're looking at this language, how would that not be a tangible employment action?
Well, it was in front of other people, and a few others in the break room chuckled at this, knowing that this is something he has joked about before, but there's no case that he was serious about this. And he had never followed through with that before, for us to know.
Okay, Counselor. Anything else?
No, just to summarize, Ms. Gray did not speak up at work or give Mr. Summers any way to correct his language around her before she quit. Therefore, she should not be held, or Mr. Summers should not be held accountable for this.
Thank you. At this time, I'd like to give the plaintiff's attorney a quick opportunity for a rebuttal.
Okay. While Mrs. Gray never outwardly voices her discomfort, it is clear by her body language that this joke is a distasteful one. Being chuckled at by fellow employees only encourages her discomfort and embarrassment. Summers directly supervised, it says in the text, that he directly supervised new employees such as Ms. Gray, and his recommendations were taken at their word when it came to keeping employees after the trial period, not necessarily meaning that he controlled her destiny, like I may have claimed earlier. But these actions by Mr. Summers clearly interfered with her work performance and creating an intimidating and hostile work environment.
Do you find it troublesome that Miss Gray did not seek afterwards, after she quit, did not seek any forms through HR or any action through the company itself?
No, I think at that point she was fed up with how everyone kind of laughed along with her treatment, whether or not they knew that it was uncomfortable. I think reasonably, any reasonable person can assume that being nicknamed after a porn star would be uncomfortable, especially for a new employee.
Thank you, Counselor. A rebuttal for the defense.
I would just say you can't assume that somebody's body language is going to be taken as such by another person. Yes, body language is very important, but you can't just assume that the way someone shows themselves to be uncomfortable is going to be taken by somebody else, because it's different in everybody. And I would argue that in the case of hostile work environment, sexual harassment, it was not severe or persuasive. And he was not serious in his joke to threaten to fire her. That was not serious. And he did not demand her to put the name tag on, more as he handed it to her.
I wanted to ask you about the name tag, because, I mean, even intent aside, the effect is really important here. Jokingly or not on his behalf, do you think the name tag and the language accompanying the name tag would rise to the level of severity?
I don't think it would. Just on the base that he's done it to every other person that he's given a nickname to.
Okay. Thank you, Counselor. Thank you, ladies.